We're broadcasting, by the way. Oh, lunch, yeah. Okay, I guess we're all here. Do you expect anybody else, or is it just the four of us?
I think I was expecting, hang on. My client was just going to come back on.
I'm sorry, I had you on mute, Miss Neighbors.
My client was going to jump back on. Let me just make sure.
Wait. Feel comfortable with it? Yeah, I just identify if they're citizens or not, let them know the right to assistance from the consulate. And then I believe that we're required to give consulate notification. Or regardless, I think. I err on the side of caution just because if we had an American child overseas, I'd want their juvenile court to let us know. And then to be a warning. But that's just more prophylactic than anything else. And so, which you did all that, let them know. Removal, deportation, removal, bar to adjustment, or bar to reentry. Yeah. For the kid's 12. He doesn't get it. Where were they from?
Mexico.
He wants to be deported.
Yes.
Okay.
The fight between the two and the fact that he was texting his sister for 21 years ago. And that's the whole reason for the seeking asylum here.
Oh, they're seeking asylum. Really?
Yes. They didn't say it, but I guess it's their involvement.
Yeah, so he wants to go back to the gang. Parents are here for safety. Okay. Tough situation. Yeah, so we'll see. But yeah, that's only the hiccup. Okay.
Suppose the contact makes it an
Yeah, the parents would say no. The parents take control. Now, and the reality is he wouldn't get deported from the United States until he's 18. Yeah, they don't deport children. So they'll go there, Homeland Security will keep record of it. And generally speaking, if you do something as a juvenile and you never get committed, they don't hold it against you. But if you get committed off a CMT or felony, then, so let's say you turn 19, you transfer to TDC, and the ITC will deport you. Or you serve in county jail or whatever. They'll put a hold on you. If it strictly says, TJ, so if you, let's say you do if you do a determinate sentence, and then you get picked up for new offense, you get out before you're 19, then you get picked up again as an adult, they will hold you and deport you based on your juvenile TJ.
But let's say you're out on an indeterminate for I can talk to the
and then you later get arrested as an adult, they'll hold you and deport you. Well, no, they'll wait till he gets arrested. They won't go looking for him so far.
Okay,
yeah, so if you do time, if you get committed and you get out before you're 19, then Homeland Security won't look for you.
Okay.
But if you do time and then you get arrested as an adult, they'll put a hold on you and then deport you. Right. Yeah. For immigration purposes. Only for immigration purposes. There's always a distinction. We just had something on that same street today.
Oh, that is.
Okay, let me I'm going to take care of this.
Okay, I'll just let you know that.
Okay. Hold on, please. Thank you. Okay, Ms. Chambers, you have your hand raised?
I do. Isn't that fun? Karen Soto Lopez is in the waiting room.
There you go. I just approved her.
Great, thank you.
I'll do that too.
Yes, Richard. Okay, she's just going to listen and watch. There we go. Okay. Yes, Ms. Ganoza, you're on mute. You have to unmute yourself.
Thank you. So CASA contacted me because one of the CASAs will be testifying. Is she allowed to watch on YouTube or not?
So she'll be testifying on the motion for continuance?
She'll be, well, yeah, she can testify to that, to the motion to extend the dismissal date.
Yeah, I'm sorry, the extension dismissal date.
I didn't know if you were taking any testimony for that or you were just hearing argument.
No, y'all are, no, I actually do need evidence on that one. So we'll, yeah, does anybody want to invoke the rule for this CASA on this motion for extension of dismissal date?
My understanding, Judge, was that this was just an argument. It just was like an argument thing by us, which is why our clients didn't have to come back. Was I wrong?
No, well, I mean, it is, but I mean, everyone's entitled to present evidence as well. I mean, do you want time to get your client on here?
No.
Okay.
But I have something I want to say. I'm sorry, Ken. I believe that I probably misread Texas Rural Civil Procedure 4 this morning. I didn't do that to try to get something I wanted or anything. It was my mistake. And so I didn't to apologize for that this morning.
Specifically, what are we talking about?
I said we don't count Saturday and Sunday.
Oh. Okay.
I believe I read it, but I wasn't doing that to be tricky or sneaky or anything like that. I just misread it.
Oh, okay. Well, we're still hearing it anyways.
Right. I just wanted to let y'all know I wasn't doing that.
Ms. Ganoza, you hear that?
Yeah, Judge, thank you.
Okay.
I just need just a couple minutes to notify if we're going to call people in support of the motion to extend.
When you say we,
I mean me.
Okay. Yes. Yeah. If you have anticipated witnesses for this, then I strongly do that. Okay, just let me know when I got it.
Yeah, Judge, I'm gonna see who I can get first.
That's fine.
I had told everybody 2 o'clock, so.
That's fine. I'm just reading other things, so I won't be paying attention to the screen.
Oh, did you decide about CASA? Should they?
If nobody objects, they're welcome to join. If nobody objects, if nobody is invoking the rule, then yeah, they can join.
Well, I know Key invoked the rule before.
I did.
For final trial.
Right.
Okay, but not for this?
Right. That's matters concluded. This is just the hearing on the motion for extension.
Okay. Judge, while we're waiting, I can start with Ms. Soto Lopez.
Okay, do you have all the communication down with them?
Well, I reached out to the behavioral therapist, Madison Webb, and sent her an email saying, can she please join? So hopefully she'll show up in the waiting room.
So just so we understand, this is 263-401. So
I'm trying to show the extraordinary circumstances of what's happened.
okay, as pled in your motion.
Let me look at my motion.
I'm going to limit you to your motion.
I'm getting to my motion too.
The statute requires motion continues have to be in writing. And so I'm going to limit to what's actually pled in writing.
Oh, then give me just a second.
Okay.
You know, I thought we were going to argue whether or not her notice was timely.
Well, that's an issue. If it's not timely, then we don't even have to worry about the motion.
Right.
If it is timely, then it needs to be heard before tomorrow.
The notice of which, Judge?
Motion for extension of dismissal date.
Okay. Are you still arguing, Key, that it's not timely when I gave you notice on Thursday?
Well, you gave us notice that wasn't filled out, which to me, I believe it should be filled out simply because then that makes the judge irrelevant in the matter. And then if, you know, we got at 9:30 at night on Friday, we got the one the judge signed, which means that's really Saturday. And the 3 days would be Sunday, Monday, Tuesday.
Well, when you, Judge, may I respond?
I thought this was a discussion between you two. I mean, other things.
What'd you
like
say?
if there's arguments, I wanted to have this on the record for you guys. We were just discussing, my understanding is we were just discussing what we're going to be taking up.
Okay.
Okay.
So I guess, are you waiting on anybody else, Ms. Ganosa?
No, because my let me see. I guess let me put you on. Okay, can I send this to Holly email and then you join in on the Zoom link? Right now. And I'm gonna just hit the link. And what's your name? That's okay. All right. All right, Judge. Judge.
This Ms. Espinoza?
So I'm calling Mr. Kyle Terrell. He's just got to get to a computer.
Okay.
I sent him the link.
Okay, so are we ready to proceed, or do you want to wait for him to get available?
I mean, I can proceed with my argument until he comes, that he would be the witness that I would call.
Well, I'd rather not do the argument before the evidence. Ms. Espinoza, about how much longer? Ms. Ganoza, about how much longer? Ms. Ganoza?
I said in about a couple of minutes. He said he just needed time to get to the computer.
Okay.
I'm trying to check in with him via phone. See if I can upload the.
All right, Ms. Ganoza, it's almost 1:40. I just soon get this started. Can you unmute yourself, please?
Yes, Your Honor.
All right, thank you. All right, so hopefully you'll be available when. Okay, so Kelly, are you ready? All right, all parties ready?
Yes, Your Honor.
All right, so Ms. Neighbors? Ms. Neighbors?
Yes, Judge.
There we go. All right. So the court will call cause number 323-107543-18, who's filed in the matter of Jeremiah Alexander Castro. We are here for two matters. One is a motion for extension of dismissal date that was filed by the attorney ad litem for the child, Ms. Ganoza, on March 25th, 2020, and filed on March 17th of 2020 by the Department of Family Protective Services. Is a motion to modify managing conservatorship. Those are the two issues we're dealing with, correct?
Yes, Your Honor.
Judge.
Okay. And so it seems to me probably the best order of things is the motion for extension of dismissal date, because that probably would leave some answer some questions that might be there if we did in reverse with a motion to modify managing. Does that sound right? Okay, so Family Code 263.401 for the extension of the dismissal date. The one-year dismissal date on this matter was November 8th, 2019. However, there was a transition to monitor return for the children, which extends the dismissal date or gives about up to 6 months to resolve the matter, at which point we are approaching that date, which is tomorrow, I believe. However, then we also have the possibility of an extension of dismissal date for up to 180 days. This court's understanding on the motion for extension of dismissal date is it is a two-factor test. one, you have to show it's in the best interest of the child. And the second factor is going to be one of two. It's either extraordinary circumstances that warrant the extension of the dismissal date, or if the parent engaged, made a good faith effort to comply with a court-ordered drug treatment program. There was no court-ordered drug treatment program for the parties. Is that correct?
That's
Yes,
correct.
Your Honor.
That's correct.
So we're only going on the extraordinary circumstances issue, correct? And usually the best interest kind of falls in place. All right, so Ms. Ganoza, according to text of rules of civil procedure, motion for continuance have to be in writing and verified. All right, so Ms. Ganoza, we'll do this. I'm going to, what I have here is an unsworn declaration, right, which is, in my understanding, not the same as a verification. All
It
right,
is, Judge. I can pull that law.
Oh, well, I was gonna give you a chance to do that, but go ahead and pull that law. Where's the law?
The unsworn declarations, if you give me just a second, because I usually have it right with me, is under the, it says it can be treated as an affidavit for all purposes. Chapter 132 of the Civil Practice and Remedies Code. Except as provided by Section B, an unsworn declaration may be used in lieu of a written sworn declaration, verification, certification, oath, or affidavit required by statute or required by rule, order, or requirement adopted as provided by law. That is CPRC 132.
The TRCP 132.
CPRC.
TCPR, right?
Civil Practice and Remedies Code.
CPRC.
The TCPR.
Judge, but if you're asking for a motion to extend date of dismissal, that it had to have an unsworn declaration, is that what you're telling me? Because my copy doesn't have one.
All right, so as good as I disagree with you, but for some reason in my mind, we're doing a motion for continuance. I think a motion for continuance requires it, but we're not. It's just extension of dismissal date. So I don't know why I went there. So it doesn't even matter. It doesn't even have to be supported by affidavit or verified. Oh no, the reason why it's titled. All right, so it's titled motion for continuance, but this is actually a motion for extension of dismissal date. Is that correct?
Right, that's what I'm trying to do, is extend the dismissal date.
Okay.
Wait, Judge, I'm confused because there was a motion for continuance filed, but I was under the impression we're talking about the motion that's titled Attorney Ad litem's motion to extend date of dismissal.
What date was that filed? Because I'm looking at a motion for continuance, which looks like she's asking for the dismissal date.
You granted the continuance, Judge.
No, I didn't grant the continuance. So where's the filing for the extension of the dismissal date?
March 25th.
March 25th?
Yes.
Okay. Okay. Okay, so we're just going with what's in the written motion, Ms. Mendoza, all right?
Yes, Your Honor.
So let's go ahead and call your first witness as far as, or exhibit or evidence.
Judge, if I may?
Ordinary circumstances. Yes.
Before we begin, I think before we, I'm afraid that we're allowing it to be tried by consent if we don't address the notice issue before she begins her argument.
Okay. Yeah, so you're objecting to even hearing this motion because of notice?
Correct.
Yes.
Okay. All right, so whose objection? Is it Ms. Abels or Ms. Neighbors?
It's a joint objection.
I'm echoing, yes.
Well, only one person can
I'll
talk.
echo Ms. Abel's objection that she was stating before we went on the record.
Okay, Ms. Abels.
Thank you, Judge. On last Thursday night at 11:52 p.m., we received by email a blank notice of hearing for the motion. What I was saying earlier is that I don't think that's a proper notice because then you would be irrelevant in this matter. Also, attorneys could just send those out and not get a hearing set.
So why would I be irrelevant?
Because there was no signature on it. And if that counts as notice, then why would we ever get your signature?
Okay, so you're talking about this March 25th file mark copy of the motion to extend this date of dismissal?
I'm talking about the notice of hearing that we got for it.
Okay, so I'm just trying to clarify. I understand that. What I'm trying to figure out is, like, I would like to see that notice of hearing. So are you saying the line on the last page of the motion to extend this date of dismissal on the document filed on March 25th, where there's nothing that says notice of hearing?
No, there was a notice of hearing emailed to us, just a notice of hearing that with her motions, you hadn't signed it yet, that we got Thursday night at 11:52 p.m.
So do you mind doing the share screen so I can see? Do you have that electronically?
Hey, Kim, can you do that?
Judge, the notice of hearing was signed.
Just a second. I'll take a look at it. I don't have it pulled. Yes, I have it right here. All right. Hold on just a second, Judge. If I can share my screen, I don't know if that, yep. Okay, perfect.
I don't know how to do that. I'm sorry. Okay, that's the one that we got Friday night at 9:30. And I think it's the email before that, Kim.
And there's an email, hold on. I'll pull up just the email so I'm not sharing things that are not relevant. All right, I'm not sure what I'm sharing right now. Share, okay. All right, can everyone see this?
All right, so just so we know what I'm looking at, because I want the record. It's a email from Laura Ganoza to Miss Neighbors. Time, date stamp, Friday, April 24th, 2020 at 9:30 p.m. And it reads, to all please see attached notice of hearing, setting attorney ad litem's motion modify temporary orders. And so, okay. All right, so there's an attachment. That was Friday at 9:30 p.m.
Right.
And
yeah.
So the attachment, if you can open that. I think you have to change the window to on the share screen.
All right, let me see. And this is the attachment.
Okay, so the attachment was the notice of hearing, stamped with the judge's signature, dated April 24th, 2020 at 8:39 a.m. The notice of hearing, setting it for today, April 27th at 8:30 a.m. Okay. Was there, I have to ask the parties, was there a conference about setting this?
No, Stephanie said.
Okay, so
no, that's not true. That's not true. Stephanie set the termination.
Okay.
No, there was no conference about setting these motions.
Judge, I did confer with CPS about my concerns. They were not going to agree. So
okay, but
that's why I had to take action as far as filing the counter petition and motion to extend.
All right, so my question was there a conference about setting this?
About setting of this? No, because we said everything at final trial. I requested previous dates from Stephanie, and there were no other dates available till after the trial. So I didn't get to confer with anybody because there were no other dates other than the trial.
Okay. It's just, I'm just trying to get to the bottom of everything. And so, all right, so this was set on Friday, the 24th. So this was this last Friday. And there's no conference. Now, I know things that Kimbo can be real low relaxed. What are the local rules among the family court judges regarding, is there a conference requirement? And if so,
yes,
did Judge Boyd or Judge Menico sign it?
I believe there's a conference rule, and it requires a statement to be included in all pleadings. I can pull those local rules up right now.
And if we're going to go there, they did not confer with me about the motion for monitored return either.
Well, Ms. Ganoza, you're just arguing one thing at a time. All right, so right now I'm just handling this motion for continuance because there's a local rule, and then, so I'm pulling up the current local family Court Rules for Tarrant County, dated November 29th, 2006. And it's approved by the majority of Texas Supreme Court justices. However, Judge Boyd did not sign on to this order. So I'm hesitant to follow the local rules if the judge of this court at that time did not subscribe to those rules. Is that fair enough?
Thank you, Your Honor.
At least, I mean, I'm not asking everyone to like it. I'm just so you understand what I'm doing. Okay, so then we just default to the Texas Rules of Civil Procedure, right? Because it's just, Ms. Abels, your argument is notice, correct?
It is, Your Honor.
Okay. So TRCP Rule 21B, which must be served upon all other parties not less than 3 days before the time specified for the hearing, unless otherwise provided by these rules or shortened by the court. All right. So Ms. Abels, your argument specifically is, I just don't want to put words in your mouth. I want you to.
That's fine. That's fine. What I was actually arguing was the night before this at 11:52 p.m., we got the notice of hearing that you hadn't signed yet. And what I was saying is, I don't believe that's notice. Because if it were notice, anybody could just sign that and people would show up because they thought there was a hearing, but the court didn't know about it.
Okay, so Ms. Neighbors, can you show me the notice in question that Ms. Abels is talking about or referring to?
Yes, Judge.
So the issue here is whether the Thursday notification serves as notice or not.
Yes,
correct?
sir. Yes,
not
sir.
the Friday, but just the Thursday notice. Okay.
Right.
It's easier to just. All right, this is the notice that Ms. Abels is referring to.
That's the Thursday one.
And and if I click right here on this, this is an unsigned notice.
Okay, so I'm looking at 230 Southwest 3rd, 871. It's talking about Rule 21. In part, Rule 21 does not expressly require that a motion and notice of hearing be filed at least 2 days before hearing. However, Rule 21 expressly requires that a motion and notice of hearing be served on opposing parties at the time of filing. Therefore, Rule 21 effectively requires that a motion and notice of hearing be filed at least 3 days before the hearing, unless otherwise provided by the Texas Rules of Civil Procedure or shortened by the court. So what I'm seeing from this, and the styling on this, is approximately $1,589 versus state. It's from 14th District out of Houston in 2007.
What's the page number?
871.
Okay.
and 873 and 74. So what this is saying is that Rule 21 doesn't require the motion and notice of hearing be filed, but does require motion and notice of hearing be served. And since it has to be filed before it's served, it effectively requires that the motion and notice be filed at least 3 days before. All right. And so going back, the Thursday copy was not a file marked copy. Is that correct?
Yes, Your Honor.
Correct.
Judge, I submitted it to Stephanie. I just didn't receive it back.
Right, but that's not filed with the court. I'm looking at this and I don't know if there's any discretion that I have on this unless there's permission from the court to shorten it.
Well, since I submitted it to Stephanie, since the court has allowed us to submit things to her and she filed them. So I didn't drive down to file it because that's what we've been doing because of the coronavirus.
But that doesn't give us notice.
But I gave you notice that evening, and notice is just supposed to give you notice. There's nothing in there that says that has to be signed by the judge. In fact, the notice of hearing on the department's motion to modify that they filed on March 17th has no judge's signature.
We're taking one thing at a time, right? All I'm focused on right now is the only thing this court is hearing is the motion to extend the date of dismissal. And so regardless, even if you provided a copy to the court coordinator, this court has been, especially during coronavirus, has been filing documents for attorneys as a courtesy, but we're not part of any attorney staff. But but the question is, Ms. Espinoza, how do I get around this existing case law? Because it says specifically, Rule 21 effectively requires that a motion and notice of hearing be filed at least 3 days before hearing, unless otherwise provided.
It was filed 3 days before hearing, Judge.
Okay,
Friday, Saturday, Sunday.
Filed with the clerk.
Filed with the clerk. It's date stamped.
You don't count Friday, and we didn't get notice till 9:30 at night, which I believe makes it really, we got notice on Saturday, which would be Sunday, Monday, Tuesday.
The rules of civil procedure went to midnight when they did the electronic.
Well, but you didn't file it electronically. Electronically, yes, it went to midnight, but you did not file it electronically.
So are y'all discussing this between you two or with me? Just out of curiosity.
Is that rhetorical?
Yeah, all right, it was rhetorical. Okay, so that's that's reasonable. All right, so I'm still trying to get back to this, right? Is the problem that I have is it has to be 3 days, and it's not 72 hours, but it's 3 days.
My response, Judge, would be that when we look at case law with regard to the 3-day rule, or even the summary judgment rule, the day of the hearing counts. So then it would be Saturday, Sunday, and Monday.
Okay, so a minute ago I asked, is the only issue is whether Thursday is sufficient or not. Like I thought Friday was a foregone conclusion. Now the argument is serving on Friday gives sufficient notice for Monday?
Because the court is saying that you didn't consider it filed until it has a file stamp till Friday. So that's why I've adjusted my argument.
It is not filed until there's a file mark on it, until it's accepted by the court, right? So there's no question about that. So now you're saying, all right, so I can show me where Friday, Saturday, Sunday, it's dates inclusive rather than exclusive.
I think it's going to be in that rule 4. Let me go there.
Okay, so the day of the act, so the first day is not to be included, but the last day is included.
Correct.
Correct, Judge.
So if Friday does not count, because that's the day of the file mark, Saturday, Sunday, and so you're saying today is the third day?
Yes, Your Honor. On Sosa versus Central Power and Light, I'm looking in O'Connor's. 909 Southwest 2nd, 893, 895, Supreme Court, 1995. It says, when Rule 4 is applied, the day on which plaintiffs file their amendment is not counted, but the 7th day after it was filed is counted. As we held in Lewis, the last day counted from the date of the filing may be the date of the hearing. Therefore, plaintiffs timely filed the second amended original counter petition. Or petition.
Well, this is my thought. I think it's a bad law, but it's the law. I think the notice is entitled to file on Friday for a Monday hearing. But I don't like it, but it is what it is. I mean, looking at Rule 4 and look at the it's Texas Government Code 311, the Code Construction Act. It supersedes Rule 4, but says the same thing. The first day is not included, but the third day is. And so
I think the issue is because 21B says that it must be served on other parties not less than 3 days before the time specified for the hearing. And I think our issue now is 9:30 at night, Friday or Saturday.
okay, here's the question. So not less than, does that mean 4 or does that mean 3? Not less than 3.
Not less than 3 days before the time specified for the hearing.
Right, at least 3 days?
Yes, sir.
Okay. Well, then the question is, Ms. Ables, do you know what time you saw it?
It was after 9:30 when I saw it. And I just happened to check my email. I wouldn't even have seen it till probably yesterday, but I accidentally checked my email for something else.
Ms. Neighbors? You're on mute.
You're on mute.
Oh, I'm trying to think about when I actually saw it. I have no idea when I actually saw it. Okay, let's see. I saw it, no. When I actually saw the signed one, I don't know when I saw it.
Well, okay, Ms. Abels, again, another law I disagree with. I think the legislature could have specified 72 hours if they wanted an actual 72 hours, but they said 3 days. I don't agree with this law, but I think it's the law. I just have to follow it. So in theory, fine. Friday night at 11:59 at night is sufficient for Monday morning at 8:30 is sufficient notice, okay. According to our legislature. So maybe they'll fix that one day. All right, so the motion to quash is overruled. All right, Ms. Anything else we can take care of before Ms. Canosa?
Judge, I have Mr. Terrell here. I can begin my argument and my presentation of evidence for my motion.
Okay, so but I'm going to remind you, this needs to be about extraordinary circumstances.
Your Honor, she never pled any extraordinary circumstances.
I'm going to say that I pled the coronavirus, which I believe would qualify as extraordinary circumstances should the court so choose.
Well, the existence of the virus itself is not. The existence of the virus itself it in of itself is not enough. You have to show the existence of the virus.
Well, the extraordinary circumstances.
Excuse me. Extraordinary circumstances that necessitate the child remaining in the temporary managed conservatorship of the department, and that the continuing employment of the department as temporary managed conservator is in the best interest of the child. So it has to be related to that. Is that fair?
But she hasn't pled that, is what I'm saying. If you want her to stick to her pleadings, that has not been pled.
She will have to stick to her pleadings. These has to be pled. All right, Ms. Canosa, please call your first witness.
I call Mr. Terrell. Kyle Terrell.
All right, Mr. Terrell.
Yes, sir.
Hello, I'm Judge Kim. All right, this is a hearing. I understand you've been subpoenaed by Ms. Canosa. All right, if you can do me a favor, if you can raise your right hand. You solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. You can lower your hand. All right, Ms. Canosa, please proceed.
Mr. Terrell, what's your occupation?
I work for a process serving company.
Okay. Judge, I'm going to pause here and I'm going to ask that Mr. Terrell's testimony be used as an offer of proof if you're limiting me to what you've set out before.
Explain that.
Okay. He's about to testify to the grounds that I listed in my motion to extend.
Okay.
That I've had difficulty securing the witnesses. The court has just instructed me that you want me to meet a true extension for the date of dismissal.
What do you mean by a true extension?
Under 260 34.401, the extraordinary circumstances and best interest of the children. So he's going to support my.
I guess I'm confused. What do you mean by a true extension as opposed to a regular extension?
When I filed this motion, the purpose of the motion was to extend the date of dismissal pursuant to the Texas Supreme Court emergency orders. That was the purpose. And that's why I didn't plead what is required by the family code for a true extension in the normal sense of what we normally would consider asking for an extension of the court.
I don't believe we can get another extension. I mean, only through the COVID Supreme Court orders, but not like through the family code. I don't think that we could.
Right. That's why I didn't plead the extraordinary circumstances nor the best interest of the child.
My concern is the issue with CPS cases is a jurisdictional issue. My jurisdiction expires, just like a motion for new trial expires after 30 days. I think the governor has the authority to modify statutes that are not constitutional through executive power. But through separation of powers, I don't think the courts have the authority to arbitrarily change any statute. I mean, if that's the point, what's the point of the legislature? Right? Why do we have separation of powers if the courts themselves can change statutes? Right? I mean, that's so. I mean, at this point, I'm here on a motion for extension of dismissal date.
And I acted pursuant to the court's orders, the Texas Supreme Court's orders. So I can call Mr. Terrell to support that.
You're saying the extension of dismissal date pursuant to the Supreme Court's orders?
Correct, Your Honor.
Okay. Which Supreme Court order referred to 263 of the Family Code?
Texas Supreme Court Emergency Order 3, which I quoted on page 2 of my motion.
We discussed this earlier.
Right. You want me to read it again?
No, it's fine. It's already on the record. All right. So Order 3, number 2B, is about deadlines to avoid the risks of disaster and still protect interests of all involved in these difficult circumstances. Right. So I'm with you. What are we, how is this avoiding the risk of disaster?
Well, Judge, I can't adequately present my case today without one of my essential witnesses, which is who Mr. Terrell will testify to, trying to attempt to serve her. But because of the coronavirus, she's a nurse practitioner at Cook's. He couldn't get to her.
But okay, so I guess my question is, how does having her as a witness avoid disaster?
It avoids disaster for this little boy. If I can prove that. Okay.
Ms. Ganoza, the disaster is very pointed at COVID-19. Right? The idea behind these emergency orders is to protect litigants, witnesses, people coming to the courthouses. But that's very specific. That's the role of the courts. They've extended these deadlines for the purpose of preventing appearing in court. What would prevent this witness from appearing on Zoom?
Well, he couldn't serve her because of the limitations of coronavirus. That's what I'm trying to tell the court. So I need additional time to secure her. He made contact with the legal department of Cook's.
And he couldn't serve the legal department?
They won't let you inside Cook's, is my understanding from everybody.
Okay, and the nurse has not left the building?
She worked at 2 locations. I think he went to 1. Well,
she works at, we were informed that she works at multiple locations and that we would not be allowed to serve her at any of those, and that they discouraged us to contact her at all. They stated on April 22nd that they would contact Ms. Ganoza, which I have no confirmation that they followed up at all.
Your Honor, I'm going to object to hearsay.
I don't even think you answered my question. I mean, my question is, she doesn't leave the hospital at all. She doesn't go home? Ms. Ganoza?
Oh, I don't know if she goes home or not. I assume she's going home.
So how is she impossible to serve? I mean, because my understanding is your argument is saying there's an unavailable witness, which is really more grounds for continuance than, okay. Go, you know what, Ms. Ganoza, just present your evidence and then I'll just make my ruling. So you're saying you want to make an offer of proof, but you were vague about it. What is your offer of proof?
Well, Judge, I think you've clarified for me, because I think we all agree that this is not a motion for extension in the true sense of how the code says it. It was a motion, I clarified my motion. The motion to extend date of dismissal was purely filed pursuant to the Texas Supreme Court order. So you asked me to put on evidence with regard to this, and I would just call Mr. Terrell to talk about his efforts in trying to locate one of my witnesses.
So Ms. Ganoza, I am bound by the law, even if I disagree with it, which is, I disagree with the Friday service for today's hearing, but we're all stuck with it. So point to me which statute I need to rule on to make my decision, so I know what you're expecting of me. Is emergency.
The only thing I'm relying on, Judge, is the Texas Supreme Court Emergency Order number 3 and number 1.
Okay. So this one-year dismissal date may be modified or suspended to avoid the risk of disaster and still protect the interests of all. Okay. So show me the risk of disaster if this wasn't, if the jurisdiction doesn't end tomorrow, and how continuing would still protect the interests of all involved.
Without being able to secure, well, do you want me to call Mr. Terrell and then I can send him on his way?
Yes. No, just, I'm sitting here
Okay.
listening. That's what I need. I need the risk of disaster and securing the interests.
Mr. Terrell, please tell the court what efforts you made to serve Emily Robinson, nurse practitioner.
The server went to Cook's and was informed that Ms. Robinson was not there, and also that I don't think she got past the front door. That I would have to check the notes on that. But I personally spoke to Cook's and they told me do not attempt service at any of our facilities, and also that she works at multiple facilities. You're not going to be able to find her unless we tell you. I asked for her voicemail. They said that we will not give you that. I asked for her email. They said as well they won't. They transferred me to what I believe to be the legal department, who said, we will take down your information, Ms. Ganoza's information, and we will have her contact Ms. Ganoza.
Okay, Mr. Terrell, I'm gonna stop you there. So you contacted Cook's legal department, correct?
Correct.
You made efforts to find Ms. Robinson at the places she works, correct?
Correct, off Pulaski, yes.
Okay. Did you try to make any efforts at all to try to locate her at home?
No, not that I believe. I would have to check with the other server on that, but no, not personally.
All right. Has the existence of the coronavirus made it particularly more difficult for you to serve Ms. Robinson?
That is the prime reason why we were not able to serve her at the office. We were specifically stated that was the reason.
Have you served other people at Cook's before?
Yes.
And had any problems before?
No.
Okay, I pass the witness, Judge.
Ms. Abels?
Mr. Terrell, when was the first time you tried to serve, what's her name, Miss Robinson?
The 22nd of April.
Okay, when was the first time you had contact with Miss Ganoza about serving Miss Robinson?
The 21st at 4:09 is when the final papers to serve her came in.
Okay. And so when did you contact Cook's Legal?
That was on the 22nd. That would be the afternoon of the 22nd. I was transferred after trying to contact Ms. Robinson's department directly.
Okay, so it's fair to say that on March 25th, you knew nothing about this?
On March 25th, I don't believe so.
Okay.
I personally did not.
Okay, pass the witness.
Neighbors?
No questions, Judge.
One follow-up question, Judge.
Yes, Ms. Canosa.
Mr. Terrell, had I contacted your process serving in March previously to serve?
Yes, you had, and that's why I said I personally don't. I would have to speak to Holly about the contents of that contact, but I do know that that was we were initially contacted and then put on hold.
Okay, thank you. I pass the witness, Judge.
All right. Ms. Abels, read across.
Who were you contacted in March to serve?
I can check that. I don't personally have that information, but I can check that right now if you mind waiting 10 seconds.
Okay, go ahead.
I could probably screen share it if I can figure that out. 1 second.
No, sir. You
Yes?
You can't screen share.
Oh, okay. But I will bring that up and get you the information. Just 1 second. And I am showing that we were contacted on the 25th. There's the custodian of records for Fort Worth ISD was one of the. And on the, and yes, there's a follow-up email for Emily Robinson as well. I see that as well.
What date was that?
I believe the final on this is the 26th of March.
Okay, but no one tried to serve her until April 22nd, right?
Yes, no, April 22nd. I believe there was a hold on that for some reason. I don't know the specifics.
Okay, and so nobody knew before April 22nd that she was going to be difficult to serve. Is that correct?
Before April 22nd, I would have to talk to the server. That would be Holly. If she was following along with it, since it was on hold, and she normally does, she would have known since it came in that it would eventually be a difficult serve due to the fact that we've had other cases with hospitals where we've been turned away for COVID.
And how long has that been going
on? For almost a month now. It's been quite a while.
Okay. Pass the witness.
Neighbors?
No questions, Judge.
Ms. Canosa?
No more questions, Judge.
All right, thank you. Please call your next witness.
Thank you, Mr. Chair.
Thank you.
I don't have any other witnesses, Judge. I would just argue.
Ms. Abels, any witnesses or exhibits?
No, sir.
Ms. Neighbors, any witnesses or exhibits?
No, Judge.
Okay, we'll go to your arguments. Ms. Canosa?
Judge, at the time that I filed the attorney ad litem's motion to extend date of dismissal, it was because the Supreme Court had issued its emergency orders, both emergency order number 1 and number 3, which does allow the court to extend the dismissal date. I have had witnesses contact me that they were unable to appear. At the time, we were going to have it in person. It was only since last week that this court scheduled a Zoom hearing. And that is why I did the motion for to extend the date of dismissal. I do believe that Ms. Robinson is one of my essential witnesses, and I've had this difficulty because of the coronavirus.
Ms. Abels?
Thank you, Judge. The Supreme Court order says that a court may extend the dismissal date to avoid risk to court staff, parties, attorneys, jurors, and the public. The third order says to prevent a disaster. I don't believe anybody knew on March 25th that it would be a disaster if Ms. Robinson wasn't served. Ms. Robinson didn't even get, the process server testified, he didn't attempt to serve her until April 22nd. He didn't sit outside the hospital and wait for her. He didn't go to her home. He didn't do anything but talk to legal and be told he couldn't come in the hospital. I think that, like Ms. Neighbors said this morning, that this is Ms. Ganoza's way to go through the back door of her lack of providing 45 days notice on her termination pleadings. There's no evidence that this would be in Jeremiah's best interest. My client has done all of the services requested and more. So we're.
Ms. Abels, do you think there's a requirement for the court to find best interest?
Based on the court orders, the Supreme Court orders?
Right.
No.
Okay. I want to make sure, because you're making the argument. And
well, I'm saying that because of the way the extension was filed, all we rely on are the Supreme Court orders. So we're not even looking at best interest. There's no, my client has done all her services plus additional services, and she continues some, but there's no need to extend this case to allow her to do more services. Today we had I counted 9 witnesses that were actually here. I've never heard of Ms. Robinson until today, so I don't know what she would have to say, but I think that if you go by the Supreme Court orders, there is no risk of disaster if you do not extend this case.
Ms. Neighbors.
Thank you, Judge. I tend to agree. I believe that the intent of the extension deadlines and the emergency orders from the Supreme Court was to prevent disaster and prevent exposure to a very easily transmitted disease. This morning, when we all logged on, we were ready for trial with multiple witnesses. The department was ready on its own motion to modify managing. And therefore, I don't believe that there is a disaster that, I don't think that even COVID-19 is preventing us from moving forward with our case. Therefore, I don't feel that there's a need for an extension here. Additionally, I do believe it is a way to get around the 45-day notice rule. I believe that all the parties were aware of the complaints made in Ms. Ganoza's motion and her motion for temporary orders that was filed later, well within the timeline for her to have filed a counter petition and given all parties 45 days notice. Without presenting too much evidence, unless the court would like to hear evidence on that, I do believe that this is simply a way to get around this 45-day notice requirement. The department is aware of the deadline that for dismissal that is tomorrow, and I don't believe that it's necessary to protect anyone from disaster that we extend it further. And just for purpose's sake, the Supreme Court order may not say that it necessarily has to be in the best interest of the child or so that justice can be done. But I feel like everything that we do in this court is really fueled by the best interest of the child standard. And the department, as evidenced by our motion that's been on file to modify managing, even as early, our original trial date was set for 3/31, doesn't believe that it's in the best interest of this child to keep this case going and to keep the department in it as temporary managing conservator.
All right, so having heard the competent evidence presented to this court on this matter, the court is diverging from 263-401 standard to determine extension dismissal date, going specifically to the Supreme Court of Texas order number 3 to order number 3.2b as pled in Ms. Ganoza's motion. Here's the thing, here's what I'm looking at is the qualifying thing is it's just modifying or suspending the rules that what the court authority has. And Supreme Court, I think, erroneously gave me authority, but looking at this test, the test is going to be to avoid the risk of disaster and still protect the interests of all involved in these difficult circumstances. There does not seem to be any evidence to indicate that not extending this deadline would incur disaster. That simply, I guess, more clearly put, is if the idea is to extend the deadline to prevent disaster, then by definition, not extending it would incur risk of disaster. I just don't see it. I mean, this court has been running Zoom for 2 weeks now, and we've had the option remotely. Supreme Court, other courts have been doing it for just about as long. I just don't think the burden has been met to show that there's a risk of disaster by not extending this deadline. It certainly may be unfortunate to the children. I don't know the facts, but purely if I'm looking at this order by the Supreme Court of Texas, I don't think that burden has been met. So going to go ahead and deny the request for extended time or suspending 263-401 of the Texas Family Code, because I don't know if there would be a disaster by not extending it. So there's no such evidence was presented. All right, so let's go ahead. State's motion to modify management conservatorship. Ms. Ganoza, you had previously mentioned that you had an objection based on the 3-day notice requirement. Is that?
Yes, Judge, I have an objection to the department's motion to modify. It was not on file for the 45 days before. Nor did I get notice of that 45 days before of that motion. They did tell us that they were going to do a motion for monitored return, but the motion was not on file, so I did not have adequate notice to know what would be in that motion.
Okay. So it's saying, this is the document filed March 17th, 2020, is that correct?
That's correct, Your Honor.
All right, and so there's a notice of hearing setting for March 31st, 2020 at 9:30 in the morning. Is that, we're all in agreement? That was the notice of hearing on the file document, correct?
Correct, Your Honor.
Yes,
okay,
Judge.
I
so,
think so.
when was the next notice given? Ms. Abels, did you have something to say?
Yeah, I think that the notice was given on the order for monitored return.
Okay, what is the filing date of that?
I want to say it's October 30th. I'm looking. I got it on November 13th.
Okay. Hold on for a second. So we have, that would have been at the original.
I'll tell you when it was filed.
Correct?
I mean, it was signed on November 7th.
So whose pleading was it? I see.
No, it's the order
Those are-
for monitored return. And it's on the last page of the order for monitored return.
Okay, again, whose pleading are we talking about?
The department's.
The department's pleading. Do we have a file mark date?
No, it's
Filed
not
at March 17th.
It's not file marked, but it was signed March 7th by Judge Smith.
I'm not going to hear a pleading that's not file marked, right? I mean, there has to be a file mark in the pleading, right?
No, because, well, you think that, I know you want that, but before when we did orders, like I've never had an order file marked.
Ms. Abels, is it a pleading or is it an order?
It's an order. It's the order for monitored return signed on November 7th.
All right, thank you. All right, I see an order signed November 7th, file marked November 11th, order for monitored return, saying a dismissal date for April 28th. So what is the objection, Ms. Abels?
I'm not objecting. I'm telling you that paragraph 3.2 says that the final trial is set for the 17th day of March 2020 at 9:30 a.m. And then it was reset to March 31st.
Right, so Ms. Abels, then again, my question is, what is the live pleading that we're proceeding on? That's all I want to know. Where's
okay, I can't answer that.
Okay.
Ms. Neighbor is going to have to answer that for you.
Ms. Neighbors, I'm just looking for the pleading that we're going forward on.
The pleading was filed on March 17th.
So that is the March 17th motion to modify management conservatorship.
Yes, I believe what Ms. Abels is referring to is in the order for monitored return, the court actually set the final trial date for March 17th.
But there was not a final trial presented.
No, there was an agreed order of continuance. All parties agreed to it, and this was at the very beginning of when the court was resetting many in-person settings before the entire county went into lockdown. All of the parties agreed to a continuance until the 31st.
All right, so we have this live pleading, which is the motion to modify management conservatorship filed on March 17th, setting it for trial on March 31st at 9:30 in the morning.
Right.
Yes.
Was that date reset?
Yeah. Yes.
Yes.
So I'm seeing a pleading file marked on March 18th, motion for continuance, referring to a trial set on March 31st. All right. That was granted. That was filed by Ms. Abels. So then what date was that extended to?
We didn't get a date. We just got an email, I guess, last week from Stephanie with today's date as the termination hearing. It's because we were all confused about what was happening.
Okay. So let me get this straight. So this motion to modify is not a final trial of the merits. So it's not entitled to the 45-day notice.
Right.
Is that fair to say? Are we all, y'all?
Yes.
I mean, I'm telling you, because I've been reading a lot of this the last hour or so. Yes.
I'm trying to apply the same logic that was applied to my petition. If I'm required 45 days, then I should get 45 days notice of the department's pleading as well.
Well, Ms. Ganoza, the difference is yours is a final trial on the merits for termination. This is a motion to modify manager. But
it's supposed to be the final trial in the case.
The final trial would be on the merits of what's originally pled, which is termination. Is that the original petition?
Yes, Judge. The original petition was for termination.
Right. So this is not a final trial on the merits. This is just a managing without termination. When I look at final,
it's a modification.
So right now, the department is a temporary managing conservator, correct?
Correct.
Yes, sir.
Yes, Judge.
So is there any final order that would change? That's what I'm trying to figure out. At this point, we're not changing anything. We're just, the child's going back to mom. Is that correct?
Right.
Yes, Judge. The motion to modify the managing conservator requests that the department's TMC be removed as TMC and the mother be reappointed as the managing conservator.
Now, Ms. Neighbors, just out of curiosity, if nothing happened today, what would be different than what your order says?
Nothing.
Well, I mean, will you stipulate to withdraw this motion and let the clock roll over? Or do you need this heard? You see where I'm going with this? Like, I'm not sure what the difference is.
That's, I mean, obviously I would prefer to have a final signed order.
Right.
But
I mean,
I understand.
do you see where I'm going with this? Like, I see no difference whether your motion is granted or denied. Either way, it's the same result, right? But I don't see this as a final trial, because whether the department non-suits it, the court grants it, or the court denies it, and nothing else is heard today, and nothing else is going to be heard today, you'll have the same result of the child going back to the mother. Is that, am I getting this right?
Yes, you are.
Yes, Judge.
And I guess, Ms. Neighbors, we could do an order that says that, you know, that signed tomorrow that says the court loses jurisdiction today. Cassandra Castro has managing conservator of her son, to something like that. I've never had a case dismissed by operation of law.
Judge, if the intention is for them to have a final order, then they set this for final trial. So you can call it a motion by title, but what they want is a final order appointing the mother, which means we're at final trial, which means I'm entitled to 45 days notice.
Okay, then just let it dismiss.
Ms. Neighbors, it's up to you. I mean, you want my ruling or not? Or does it matter to you?
I mean, I disagree that the motion to modify is a final trial. I don't think that is accurate. However,
not just as a motion to modify, it's a motion to modify that changes nothing other than removing a temporary.
Right.
Yeah.
Here's my question. Well, let's make this simple. Article 1, Section 13, Texas Constitution. I mean, everyone's entitled to have access to the courts for remedies of their grievances. So what's the matter of controversy right now on this motion to modify? I'm not talking about procedure. What is the substantive issue and controversy? So the state is wanting to withdraw as temporary managing and just return the child to mom, correct?
She hasn't.
Okay, disabled. Is there any controversy to this as the mother?
No, sir.
Okay, Ms. Ganoza, is there any controversy in this as the ad litem for the child?
Yes, the child's not safe where he is.
So the child is not safe in the temporary care of the department?
Of his mother.
Well, but right now the managed conservator is the department.
Right.
Child with the mother. So you're disagreeing with their decision about the child, and so you wish for them to remain in control to continue to make that decision?
Judge, it's my job to advocate for his safety and to present the evidence, which I've tried to do. I've been pleading since February. Because of the coronavirus, we've had difficulty scheduling a hearing. I didn't have enough to bring it on emergency. So I've tried to schedule the hearing. We couldn't do it any sooner than today, which are my motion to modify and remove the child from the mother. That is what I have pled for. So I understand where the court is coming from, but when we finish this, I would just ask that I could do an offer of proof with regard to that my petition was still timely filed, because that's what I plan to do. You're asking if there's an issue. There is an issue. The issue is whether this child is safe with the mother when there's been additional 3 outcries since the monitored return.
So Ms. Ganoza, hold on. Right now, the department is the managing conservator of the child. Your objection to this, instead of the department leaving as a managing conservator, is to make the department remain as managing conservator.
Right, and remove the child from the mother.
But regardless, you would have no control over what child is. What you're saying is currently the CPS is unfit to make the right decisions for the child by placing the child in danger. So you're objecting to make sure the child stays with the same agency that put the child in danger.
I don't like it, Judge.
But I just want to make sure that's your legal theory. That's the foundation of all this.
My legal theory is to oppose their motion to modify by naming the mother as managing conservator.
Which will make the child remain with the agency that placed the child that you feel is dangerous.
Yes, Your Honor. I'm hoping they get it right the second time.
All right, well, you want your hearing? Get your hearing. I mean, I think you're entitled. I don't think this is a final order because you're not changing any property interest, any liberty interest. So at this point, I mean, I think you're entitled to the hearing, so you can have the hearing. It's going to, you can make your objections as you go. All right, Ms. Neighbors. You have a witness?
Key, did you want to say something? I apologize.
Judge, I was just going to point out that Family Code Section 105 states that in a suit, the court may make temporary orders, including the modification of a prior temporary order for the safety of the child. And I think that that's what this is. That's what their motion is. It's a motion to modify a prior temporary order. It's not a final trial.
I agree. That's what I'm saying. I think we're entitled to, the state is entitled to have this heard, and the attorneys and parties are entitled to object to it. And it's my job to listen to the evidence and make my decision.
That's fine.
All right, Ms. Neighbors, I mean, the pleading speaks for itself. It's kind of a res ipsa. So, do you have any evidence or witnesses?
Judge, I have my client, Karen Soto Lopez. She has already sworn to an affidavit that's on file with the motion. I'm willing to rest on that affidavit. However, I'm not sure if that's procedurally sound. I think I'll just go ahead.
I can take notice of that.
Pardon?
I can take judicial notice of that.
Okay, Judge. And then if I may briefly, make an argument as to my motion. I don't necessarily need to call a witness. Everything is in her affidavit.
Okay. All right. Well, I'll certainly allow you for closing. Ms. Abels, do you have any witnesses or evidence?
I don't, unless you want to hear from my client, and then I can text her and tell her to hop back on.
I can't make your strategy decisions for you, Ms. Abels.
Okay, I'm good.
All right. Ms. Ganoza, any evidence or exhibits?
I do have some, Judge.
All right. Please call your first witness.
So you're starting with me?
Yes.
Okay. I was waiting to see. All right, then I guess I call Karen Soto. That way I can let everybody else know.
All right, Ms. Soto,
Yes, Your Honor.
please raise your right hand. You solemnly swear the testimony you're about to give at this cause currently trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay. Please proceed, Ms. Canosa.
All right, Ms. Soto Lopez, please state your name for the record.
My name is Karen Soto Lopez.
All right, when you got this case, did you have a chance to review the facts on why Jeremiah came into care?
Yes.
Your Honor, if I may object,
Say your
I would
objection.
like to object to any evidence being introduced that happened after the monitored return order. The monitored return was heavily litigated and those issues have already been decided. So therefore I'm going to object to any evidence being presented of anything that occurred prior to that monitored return order, which took place in November of 2019.
Right, yes, so that's sustained. Ms. Canosa, that's not going to be relevant. There was a hearing. The court decided that it was in the best interest of the child to place the child with the mother on this monitored return. And so the rest of it's just not relevant. I mean, unless you can, I mean, if you're convinced it is, then I'll let you explore a little bit, but we're not going to go down a fishing trip right now.
Yes, Your Honor, I understand. All right, so for the court, since this is Judge Kim has not heard this case before, will you tell him when Jeremiah was returned home?
He was returned home in October of 2019.
Okay, Ms. Soto, if you can speak louder or maybe closer to the microphone, you have trouble hearing you. Thank you. Can you repeat that?
October of 2019.
Okay. And at that time, was there an open investigation with regard to an injury Jeremiah had received?
At the time that he was returned, no.
Was the investigation still open?
It was closed at that time.
Before the day of trial?
Give me a second. It was not closed. It was not closed.
Okay. And what was the injury that he received at that time?
I
So
believe
I'm going to interrupt for a second. So the question is about the injuries he had while he was in CPS's care, correct?
Correct, Judge. In October.
And you're objecting to CPS giving up control of this child?
To the mother, because the mother injured him.
In CPS's care?
Obviously, they're not living with her. So it happened when they weren't watching.
But they're responsible. Like CPS was responsible for this child.
I agree, Judge. This is a case where they didn't do what they were supposed to do.
Okay. Please answer the question.
I believe he had a bruise on the back of his back.
And what did the mother say was the reason that that happened?
Objection, hearsay.
It's a party. It's not hearsay.
No, this is hearsay exception. So this is 6 months ago, right? That's what we're talking about?
Yes.
Judge, I'm developing a course of conduct. So yes.
A course of conduct of what? I mean, help me out here.
Oh, there's going to be at least 3 incidences past that one incident. That the child has gotten injured in mother's care.
Okay.
So I'm starting with the first one.
No, it's still sustained.
All right. Since then, in November.
I mean, when you roll your eyes, do you want to qualify as an expert? She's not. If you're talking about medical injuries, then qualify as an expert should talk about medical injuries. That's Judge, that's why I'm sustaining this.
But Judge, the reason I was concerned is because the objection was hearsay and it's about the mother, Cassandra. So that's, as the court correctly stated, it's an exception to the hearsay exception.
the law is very clear that in civil matters, the court can make a ruling if any legally recognized basis for that decision. My decision is based on the fact that she's not a medical expert. If you wish to take a 702 hearing to qualify her as a medical expert, we can, but I don't want her talking about injuries to a child if she's not an expert that can help define her fact and determine what extent these injuries are. Is that fair?
Yes, Judge, but my question was, what did mother say was the cause of that injury? What did she say? The statement mother made.
And I'm
so
objecting to
just
that.
want to hear her statement. Because you had told me this whole purpose of this is going this pattern of injuries.
Right, Judge. But mother makes different excuses.
If you're going into pattern of injuries, then I want a qualified medical expert to talk about these injuries, not a layperson, and not certainly not hearsay from a person that you don't think is fit to be around this child.
Judge, the rules allow me to call her as a fact witness. She can talk about what she observed, what she saw on the child, what marks she saw on the child. She may not be able to diagnose them as to how those injuries were occurred. But my question, my original question was, what did mother say? What was her excuse as to how that injury occurred? That's just a statement from a party.
Yes, Ms. Canosa, you told me the reason for this. Look, I said sustained, okay? And that's
I'll move on, Judge.
Decision.
All right, so in November, the CPS received an outcry report?
Yes.
Okay, and how was the child injured then? What was the report about?
The child had was stated that he was spanked by the mom.
Okay, and did CPS open an investigation?
Yes.
All right. And did you interview the child?
I did.
Okay, now what is CPS's policy with regard to children who are on a monitored return? Are parents allowed to physically discipline their children?
No.
Okay. And did you go over that with Ms. Castro?
Yes.
All right. And you'd gone over that with her before, correct?
Yes.
All right. Did she deny that she had spanked him?
Yes.
All right. Now, okay. And did you notify me of that outcry?
No.
Ad litem. Okay. And then in December, did CPS receive another outcry?
Yes.
Okay. And what was that outcry regarding?
Again, the child had stated that mom had hit him.
And was an investigation opened?
Yes.
Okay. And did you talk to the child about that?
Yes.
And what did he say?
He could not give me a clear answer. He stated that he gets in trouble, that mom hits him, slapped him. When I asked him to go a little bit into more detail where, he could not tell me. He couldn't tell me a straight story.
All right. And then so that was December. So did you notify the ad litem about that injury?
No.
Okay. And why didn't you notify the ad litem?
Since I went out and visited the child, I did not see any marks or bruising that would be concerning. Also, I spoke to the investigators that also did their own investigation, and I was aware that they were going to rule it out. So I should have notified you, but I did not see a need since there was no concern that the child was in danger.
So it doesn't concern you that the mother continued to break the rules?
Objection. Assumes facts not in evidence.
And
So it didn't concern you that the child was reporting that his mom had hit him?
It did concern me.
Okay. Now, with regard to the latest outcry, there was one in February, correct?
Correct.
All right. And what was that outcry?
Also, the child had stated that mom spanked him.
Was it spanked or slapped?
I believe it said slapped on the report.
Okay. And did you interview him with regard to that?
Yes.
Okay, and CPS actually received multiple reports about the slapping incident, correct?
I only received one that came through. I don't know if there were multiple calls.
Okay, did you receive a report from me as well?
Yes.
So that would be 2, correct?
Correct.
All right. And did you interview him about that?
Yes.
And did he acknowledge that mom had slapped him?
Yes.
Your Honor, objection, asked and answered.
Same.
I'm sorry, Judge, what?
Sustain.
So with regard to, did he say where mom slapped him?
He pointed everywhere on his body.
Now, CPS's main role is to protect children, correct?
Correct.
All right. And during the course of this case, these weren't the only 3 outcries that the child has done, correct?
Correct.
Your Honor, objection, this is relating to my previous objection about any event that took place after the monitored return was ordered. So I reiterate my objection.
Ms. Ganoza, you said these are not the only 3. Are you referring to anything that happened before?
I was, Judge, to show a continuing course.
Okay. Ms. Ganoza, we already talked about this. All right, I sustained the objection. Things that happened before the return to the mom in, I guess, October, it's not admissible.
Yes, Your Honor. So Jeremiah's been diagnosed with some conditions, correct?
I don't.
Your Honor, objection, hearsay. Any answer would be based on hearsay.
Ms. Ganoza, how do you know? How does she know?
Because she prepares them in her reports, Judge.
Okay, that's not sufficient. Sustained.
Has Jeremiah been diagnosed as autistic?
No, I haven't received a report stating that.
So that's not in the strike down.
That's asked to be answered.
Now, since November, mom was supposed to start play therapy, but that didn't get set up till February. Is that correct?
Correct.
And the behavioral therapy didn't start till February. Is that right?
That's incorrect.
Okay, so did that continue?
Yes, behavioral therapy continued once the child was placed with mom in October.
Okay, but then it was discontinued at some point, correct?
It was delayed.
By delayed, what do you mean?
I believe that there was some issues between the therapist being allowed in the home. So we had to obtain a new therapist to work with mom.
When was the last time that you saw Jeremiah in person?
I saw him on April 22nd.
And as part of your job, you're supposed to check in with mom's medication regimen, correct?
Correct.
Okay, so what did you do to check on that this last time?
I made sure mom had medication. I spoke to her concerning with the last time that she has taken her medication and followed up that she is still able to follow up with MHMR and make sure she continues on her treatment.
Did you verify that with MHMR personally yourself?
I did not reach out between the 22nd and now to MHMR.
Okay, so when's the last time you contacted MHMR?
I believe that was the last month, March.
And at that time, was she in compliance?
Yes.
Okay, I passed the witness, Judge.
Ms. Havels?
Thank you, Judge. Karen, was it my client's fault that the therapy got delayed?
No.
Okay. And at one point they had to get some kind of therapist, right?
Correct.
And so right now they are currently in their family and the child is in play therapy, correct?
Yes.
Okay. And then does my client still send you pictures twice a day, almost every day, of Jeremiah so you can see that there are no marks on him?
Yes.
Okay. And during the 3 incidents that Ms. Ganoza talked to you about, did you ever see marks on him?
During the 3 incidents, no.
Okay. And did CPS investigate all of those?
Yes.
And how did they dispose of them?
They ruled them out.
Okay. And then if you remember when we were in Judge Smith's courtroom for the monitor return hearing, did you testify that that case, that investigation that was open, they had stopped investigating? They had told you they were going to rule it out, but they hadn't closed it yet?
Correct. Yes.
Okay. So it was open only because in the computer it hadn't been closed.
Correct.
Okay. Pass the witness.
Papers.
Karen, just a few questions. So as Ms. Abel reiterated, you frequently check in with his mom, is that right?
Yes.
How often prior to the coronavirus restrictions were you going out to see Jeremiah in his placement with his mother?
I would go at least once a week.
When the outcry was made in February, you had a chance to interview Jeremiah, correct?
Correct.
And you previously testified that he couldn't really give you a firm location of where his mother had slapped him, is that right?
Correct. Yes, ma'am.
When the original case was opened, was Jeremiah very specific about his outcries of physical abuse by his mother?
Yes.
Was he very specific about the things that he had done to her?
Yes.
Or she had done to him, excuse me.
Yes, he was.
And at that point, did that color your opinion of the validity of his later outcry in February?
I'm sorry, can you rephrase that?
Did his lack of specificity color your opinion about the validity of the later outcries?
Yes.
And how so?
Well, I determined when he previously used to be able to specifically tell me what happened, and I spoke to mom.
Judge, I'm going to object. If we're going to limit about the previous, then I'm going to object to her. Ask for a motion to strike anything referring previous to that monitored return.
If I may respond, Judge.
Yes, Ms. Davis.
This testimony is about how her previous interaction with Jeremiah and his previous outcries colored her opinion of the later outcries, which were explored in depth. Without this testimony, without exploring how she formed the basis for the fact that she did not believe they were outcries that put the child in danger, we can't really understand where her head was, especially if the ad litem is alleging that CPS is not doing their job.
I'm just to stand the objection. Let's talk about what's going on with the child right now on something that's honestly not going to change anything.
Do you believe it's in Jeremiah's best interest to be returned to his, to have the department removed as temporary managing conservator?
Yes.
And do you believe that Jeremiah is in danger at home with his mother?
No.
Do you think that granting this motion would be in the best interest of the child?
Yes.
Would you say that you spend more time with Jeremiah on this case than you do normally on a case?
Yes.
So you are much more involved in this case than you are in your standard case?
Yes.
And knowing that, it is still your opinion that it's better for Jeremiah to return home to his mom?
Yes.
Pass the witness, Your Honor.
Ms. Canosa?
Judge, I'm trying to upload a picture, but I'm having some difficulty.
Hold on, uploading picture for what, to introduce?
Yes, as an exhibit of a recent injury.
How about offending it before you publish
Well,
it?
Judge, I can't upload it to her. That's my problem.
Well, No, because all documents are supposed to be provided to the court. All exhibits are supposed to be provided to court prior to the hearing and marked and labeled. So the other
I
parties.
did that.
Okay, so all the parties should have it already. Right?
They do, but I don't know if the witness has it.
So which exhibit are we talking about?
We were talking about, let me get there again. Castro Exhibit 16.
Okay, hold on a second. Let's just see. Okay, all right, start your share screen, Ms. Gomeza.
Yeah, Judge, that's what, can I have a 5-minute reset? I can't get it up on the, I hit file right here on the chat box and it's not letting me do that.
Oh, it's not the chat box, it's share screen.
Oh, okay. Okay, let me see if it works. Let's see if it lets me do it. Can you see that?
Yes.
Okay. So, Ms. Castro, you sent me these photos. Oh, first of all, take a look at these photos. I'll go slower. All right. Have you seen these photos before?
I have.
Okay. Is this a fair and accurate representation of what the marks looked like at the time that these photos were taken?
Yes, slightly darker, but yes.
Right, the lighting is not so good. All right, at this time I would offer a attorney ad litem's exhibit 16.
Objection. Objection. Proper foundation.
Same.
Who are these photos of?
Jeremiah.
Okay, and when were these taken?
Exact date. I don't remember. I don't have that date in front of me.
Could it be December 2019?
That sounds about right.
Okay. All right, at this time I offer attorney ad litem's exhibit 16.
Objection, foundation.
Ms. Ganozo, please proceed.
Okay. Sorry, Judge, did you do a ruling?
Yes, it says the same. The objection was predicate.
Okay, let me see how to get to the next thing. All right, Ms. Soto, you had a chance to visit with him this last month, correct?
Correct.
And during that visit, did he indicate to you that he didn't want to live at home?
On April 22nd, he did not indicate that.
And previous to that, had he indicated that?
Previously,
Your Honor, I'm going to object to the testimony of a child. It's hearsay, and it's not an outcry that falls under any exception.
That's sustained.
Did you write in a report that he didn't want to go home?
I notated on my documentation.
Okay. Trying to see how to shrink. Okay. Let's see what else I got here. All right, one more. Let's see. All right. How old is Jeremiah?
I believe he just turned 5.
Okay. And he's currently going to be set up for a psychological assessment. Is that right?
He is in the process of completing his psychological assessment.
Okay. Do you know the results of any of his previous assessments?
Object there before the monitor return.
As good as it has to do with after the monitor return, that's fine.
Okay. Is he being evaluated for anything new?
Yes.
Okay, what is he being evaluated for?
Autism.
All right. And with regard, oh, let's see, did I share screen? I'm sorry. New share. Can y'all see that? Can you see a new picture?
Yes. Jeremiah.
Holding a box.
Yes. Okay. Who's the child in this picture?
This is Jeremiah.
All right. And where was this picture taken?
This was taken at the OCOK office.
Okay. And was this picture taken when you arranged a visit for me to go and see him, correct?
Yes.
And you allowed him to take a toy, is that right?
Right.
This is a fair and accurate representation of what he looked like on that day.
Yes.
Judge, at this time, I would offer attorney ad litem's exhibit 18.
Objection predicate.
Sustained.
Ms. Soto, are you familiar with the scene depicted?
Yes.
Okay. Is the photo an accurate representation of the scene?
Yes.
Judge, at this time, I would offer attorney ad litem's exhibit 18.
Objection predicate.
I'm looking off the toolkit.
I think she's still asking the questions, so for now denied. We'll see.
What'd you say?
Oh, at this point tonight, I think she was in the middle of a question, asking questions.
Okay, I'm sorry.
She hasn't offered to publish yet or admit.
Is this photograph an accurate representation of the scene as you remember it on that day? Ms. Soto?
Yes.
All right, at this time, I'd offer attorney ad litem's exhibit 18.
Objection predicate.
Same.
Judge, I'm looking at Texas Rule of Evidence 1002 and 1003 and 1001.
Okay.
I believe I've laid the predicate.
You haven't. I sustain the objection.
Okay, I passed the witness.
Ms. Abels?
No questions, Your Honor.
Ms. Neighbors?
Sorry, I'm distracted. Ms. Ganoza, can you stop sharing your screen? Sorry, we can see everything that you're doing.
I'm trying to find the Zoom. I have so many buttons. I don't know how to get this one off of here.
I'll just keep like a brief,
I can do it
briefly,
from here.
Your Honor. Okay, great. Ms. Soto Lopez, when those marks were, the marks that were shown of Jeremiah from December that were just entered into evidence, did the mother also make a report as to the daycare?
Yes.
To CPS about that?
Yes.
Did the mother allege, was there an allegation that those marks came from his daycare?
Yes.
And is it your understanding that the daycare refused to allow Jeremiah back after that day?
Correct.
That's what Mr. Honor.
Mr. President?
Did you investigate personally with the daycare?
No. I called.
But you didn't make any further investigation?
I'm not allowed to do that.
Okay. And to your knowledge, licensing didn't do any further investigation, correct?
Correct.
All right. I passed the witness, Judge.
Ms. Abels?
Nothing, Your Honor.
Ms. Neighbors?
No further questions, Your Honor.
So please call your next witness. This is a motion to modify. I expect this to be about 30 minutes per party, and you're 30 minutes on this one witness. So how much
Judge,
further?
I don't know who's in the, Madison Webb says she's in the waiting room.
No, people are in the waiting room, but this is not going to be a 3-hour motion to modify hearing. Like, there's no time for that. So these should take an hour tops for all parties involved. So how many more witnesses do you anticipate?
Well, I want to call Madison Webb. I can get rid of some, Anthony Avery and the Casa.
Okay, you got 15 minutes for the remainder of your case in chief. Okay. And it's
15 minutes for the remainder of my entire case?
Yes, I mean 45 minutes on a motion to modify when the child has been in custody of the court for 16 months. Dismissal date is tomorrow. Like, there's not that much to show. Either the child should go back to the Department of Family Protective Services or should go back to the mom. It's either or. I mean, it's really, that's the only issue here. So I'll go ahead and admit the rest of the participants into the room. Okay, who's the next witness?
I'm going to go ahead and dismiss Ms. Levy since you've limited my time, if that's okay with you, Judge.
They're your witnesses, but there's no reason why it should take 45 minutes on a motion to modify when it's this late in this child's experience with CPS. So.
Ms. Levy, thank you. You can go now.
Thank you.
I'm going to call Ms. Webb, and then I'll call Mr. Avery. I think Ms. Abels invoked the rule, so I don't know if you need to put one back in.
She has not
I
invoked.
don't care about the rule anymore. I don't care about it.
No, Ms. Ganoza, she invoked the rule for the final trial and the counter petition this morning. Then at the end of that, after my ruling, I told all the witnesses, the rule, this is over, you were released from the rule. Or I told the attorneys to tell them that. We are a separate proceeding. There is no rule been invoked on this one. Okay.
Okay.
So Ms. Webb?
Yes, sir.
All right, if you could raise your right hand, please. Can you say something?
Yes.
Okay, there we go. All right. Do you solemnly swear that the testimony you're about to give is caused currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You can lower your hand. Ms. Ganoza, please proceed.
And Ms. Webb, state your name for the record.
Madison Webb.
All right. And how do you know Jeremiah?
I'm his previous behavior specialist.
Okay. And about how long have you worked with him?
I worked with him for about 6 to 8 months while he was in foster care and bio mom's care.
Okay. What new behaviors have you seen since he's been returned to his mother?
I saw an increase of aggression. I saw profanity. I saw mild self-harm.
When you say mild self-harm, what do you mean?
Taking his fist and banging it on his head. During a tantrum, sometimes he will bang his head against the wall. Superficial scratching on his arm.
Okay. And did you happen to make reports to CPS?
Yes.
Your Honor, that is privileged by statute.
I don't know enough. How do you know that information? So, Ms. Webb, you're saying you reported this to CPS?
I reported outcries of abuse.
Okay. And under what premise did you report this information to the department?
For physical abuse.
Or no, under what, like as a mandatory referrer?
Yes.
Okay, yes, that's privilege. So that's sustained.
Did you happen to see bruises on Jeremiah?
Yes.
Okay. And was that in what month? Do you remember?
There was one in December and there was one in February.
Okay. So you also had a bruise in February?
Yes.
All right. Where was that bruise?
That bruise, I believe, was on his face.
Can you repeat that, Ms. Webb? On his what?
Face.
Face. Thank you.
Did he tell you how he got the injury on his face?
Objection, hearsay.
Sustained. Well, Ms. Ganoza,
It's abuse. Response? It's abuse, Judge. It's a report of abuse. An outcry is what I would consider that.
That's
a bruise.
Yeah, that's sustained.
Why did you call? Did you make a call after seeing the bruise in February?
Objection. It's privileged information.
I'm gonna let her answer that one.
Okay.
Yes.
No, it's why did you make that? Just the why.
Because I saw a bruise on his face.
Why did you think it was abuse?
Because of his statements that he made.
And what did he say?
That his mom's hit him.
Okay. What are some of the other concerns you have about Jeremiah?
I have concerns about his increased behaviors, which is what I've been working on, but also the lack of attending school.
Okay. So how were you able to engage with the mother, Cassandra, in some of the behavioral therapy that you do?
I did in-home sessions.
Okay. And how did that go?
Jeremiah did very well with me. Mom had minimal engagement with the sessions.
Did she ever make any statements that concerned you?
Objection, hearsay.
Response.
Judge, it's a party, so it's an exception to the hearsay rule.
Overruled.
Yes.
And what were those statements?
That he needed a good spanking sometimes.
Were you trying to give her alternative methods of disciplining him?
Yes.
And what did those include?
Sticker charts, alternative punishments, reward systems, things like that.
Now, what are Jeremiah's triggers? Were you able to determine that?
Yes.
And what are those?
Being told no, not getting his way, delayed gratification, a change in consistency.
Do you have concerns, or what are your concerns about him continuing to live with his mom?
I have concerns, obviously, about the outcries that have been made, but also not attending school as much as he should, and the increase of aggression and behaviors.
Can't pass the witness.
Ms. Abels?
Thank you, Judge. When did you stop seeing Jeremiah and his mom?
In March, beginning of March.
Okay. And when did Cassandra say that the child needed a good spanking?
Back in January, I believe.
Of this year?
Yes.
Okay. And you understand that mom knew you were making CPS referral on her, right?
I don't know what she knew.
Okay. Would you expect any client to trust you if they knew you were doing that?
Depends on the client.
You think there are people who would trust you if they knew you continually reported them to CPS?
I can't speak for all my clients.
You don't think that's just common sense?
Like I said, I can't speak for all my clients.
Pass the witness.
Neighbors? Neighbors?
Sorry, Judge. I'm just gathering my thoughts. Yeah, no questions, Judge.
Ms. Ganoza, redirect.
No further questions, Judge.
All right. Thank you, Ms. Webb. Please call your next witness.
Thank you.
I call Anthony Avery.
All right, Mr. Avery.
Sorry, I was muted. Yes, sir, I'm here.
Okay, if you can raise your right hand for me. You solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. You can lower your hand. Ms. Ganoza, please proceed.
Mr. Avery, state your name for the record.
Anthony Avery.
Okay, and how do you know Jeremiah?
I'm the principal at Jeremiah's current elementary school.
What school is that?
Hazel Harvey Peace Elementary in Fort Worth, Texas.
Okay, and what involvement have you had with Jeremiah?
Mainly I deal with Jeremiah during discipline issues, tantrums, when Jeremiah is sent out of class for disruptive or violent behavior.
Have you had an opportunity to engage with his mom to address those behaviors?
I have on a few occasions, but most of those interactions have happened with his teacher, mostly more than I have.
Okay. And what can you describe for the court what his behaviors have been?
When Jeremiah comes to me, the behavior is very escalated, cussing, yelling, and then that escalates to hitting, kicking, attempting to scratch, mostly me and my assistant principal and whoever else is handling the behavior at the time.
So at some point it escalated so much that he hit your assistant principals or scratched her?
Yes, both of us.
Okay, and was he suspended for that?
He has been suspended. I'm looking at the attendance record right now. Officially, he's been suspended twice off campus, meaning he was sent home. The other instances, he was kept in the office until he calmed down, and then we determined he could go back to class. So the behavior only warranted him being kicked off campus twice. One of those incidents was when my assistant principal was scratched to the point of her lip bleeding.
So with regard to Jeremiah, you said he missed days of school. How many days did he miss?
I am actually in the attendance system, so I can tell you right now, we have 11 days that he's missed, and he's only been with us since early November. The last day he had off was February 19th, so just in that 4-month span, he's missed 11 days of school.
Does that concern you?
Absolutely, yeah. The district has us send out warning letters at 5 days, and then the actual attendance clerk that works at the high school sends out letters at 10 days. So that's a significant amount of time for only 4 months of schooling.
Do you think that that's had an effect on his schooling as far as his ability to learn?
I can tell you that we see our most extreme behaviors from Jeremiah on days where he's missed a stretch of time. Say if he has 1 to 2 days off and he comes back to us, those were the days where we saw the most violent behavior, I can say, where the behavior was further escalated than just cussing and yelling and disrupting.
All right, at this time, see if I can do this. Mr. Avery, can you see that?
Yes, ma'am.
Okay, so is it the practice of Fort Worth ISD to keep attendance records?
It is, yes.
All right, and those are entered every day, is that right?
Yes.
And on occasion, you do printouts like this if you want to look at a child's attendance?
Yes.
Okay, and did I ask you to print this out for me?
Yes.
At this time, I would offer attorney ad litem's Exhibit 5.
Objection predicate.
Same.
Okay, got it there. All right. Okay, all right, Mr. Avery, just a couple last questions.
Sure.
Did you have some concerns that happened with Miss Castro at a family math night? Would you describe those for the court?
Sure. We had like you said, a family math night event where families were invited to come and participate in activities with their children. Jeremiah was in the cafeteria with his family friend. Mom finally joined. Then his teacher actually came to get me because there was some sort of disturbance in the cafeteria.
Your Honor, I'm going to object at this time. May I please take the witness on board ire?
Regarding?
Regarding whether or not Mr. Avery is about to testify to hearsay.
Sure.
All right, Mr. Avery, were you present when any kind of disturbance occurred at the family math night?
Yes.
Did you physically observe disturbances that occurred?
Yes.
Okay, fine. Withdraw my objection, Your Honor.
Okay, Ms. Ganoza.
What did you, without saying, well, you can say what Ms. Castro said. You just cannot repeat what anybody else said.
Yes.
What did you observe with regard to a disturbance involving Ms. Castro?
So when I walked into the cafeteria, Ms. Castro was having some sort of argument with the male family member that was there. I stood there to try to calm the situation down. She was arguing with him about his car keys. She wanted them. That argument was escalating, and to the point where I saw her grab him and attempt to sort of pull him off of the chair that he was sitting on until he would give her the keys. At that point, I stepped in and I simply said, you know, we can't do this here. She responded, he won't give me the keys, and I've asked him, and I repeated that we can't do this here. At that point, she stood there for, you know, a short amount of time, and then she left campus.
Was that the only time that you've seen Ms. Castro be aggressive?
That's the only time I've witnessed her being physical, yes.
Okay. I pass the witness, Judge.
All right. Thank you, Ms. Avery. All right, Ms. Ganoza, that's 3:45. So, Ms. Ables, let's see. Ms. Neighbors, Ms. Ables, did you have, I already asked you, correct? You don't have any witnesses? Okay.
Yeah,
So let's go to closing arguments.
Oh, I'm sorry, Judge.
Yes, Ms. Neighbors, would you like to proceed?
Yes, Judge. And may it please the court, Your Honor, Miss Cassandra Castro has done everything that the department believes is necessary to have the department be removed from this case at this time. The child has been on monitored return since November 7th, and the department is comfortable due to the intense involvement of our caseworker, our OCOK permanency specialist, and we rely on her opinion of the case as well as all the reports that have been ruled out by the department. Based on all of that, the department believes that at this time it's no longer necessary for the department to remain as the temporary managing conservator of Jeremiah. Though Jeremiah does exhibit some disturbing behaviors, that in and of itself doesn't justify the department's continued managing conservatorship of this child. We do hope that we have done our job in providing her the resources she needs in order to help Jeremiah to succeed. However, our continued involvement is no longer necessary. So we would ask that you grant the department's motion to modify managing conservator and dismiss the department from this case.
Ms. Abels?
Thank you, Judge. I may it please the court. My client started services before she got a service plan. She was very honest and open at the very beginning with me and with CPS about what she had done. My client feels like, and I kind of agree with her, that she's been harassed by the ad litem and the CASA advocate. She has a child with a lot of problems, and she understands that these problems are going to last for a long time, and she's working on what you can do with him. I think his psych said that he's not afraid of adults. He's not afraid of anybody. And he, like the same thing, one thing will work with him this day, it won't work with him again. And so she understands that, but she says that since he's been in foster care, he's a better kid, that she can express to you what she's learned, how to deal with him. And she's worked really hard. She got discharged from therapy, but she's continuing it because she felt like she needed it. And so she has surrounded herself with a pretty good support system. So I agree with Ms. Neighbors and the department, and I believe that they need to be removed as a managing conservator.
Ms. Ganoza?
Judge, I would just ask that if I could make an offer of proof before I finish.
Offer of proof of?
What I would have shown the court had I been allowed to proceed.
Sure. Just make sure you speak slow enough for the reporter.
Yes, Your Honor, I will. So if the court had found that my petition had been timely, then I believe that the evidence would show that either termination or permanent managing to conservatorship to the department would be in the best interest of the child. As far as termination, there would have been evidence, had I allowed to introduce it, that the mother had knowingly placed or knowingly allowed the child to remain in conditions or surroundings which endanger the physical or emotional.
Ms. Ganoza, you're just making an argument. What's your offer of proof? What evidence are you not able to submit?
Oh, there would have been pictures of a injury that looks like a cigarette burn on his back. That was in October. There would have been pictures that occurred of marks and bruises that occurred in April of 2019. There would have also been evidence with regard to his medical records, and those medical records would have shown that the nurse practitioner, Emily Robinson, would have said that they look like, that the abrasion on his back looked like a cigarette burn. I also would have offered evidence.
It's an offer of proof. How is this an offer? Like, how are you need to make the offer of proof.
Her past.
No, I don't need the argument. I need your offer of proof.
Right. So the next thing I would have offered was her criminal record of her conviction of her assault of family violence.
But Ms. Ganoza, this is not an offer of proof. Like, you need to make an offer of proof. You can't just tell me what your case is. You need to make, you're preserving this for appeal. So you need to establish this for appeal.
Okay, for appeal, Texas Rule of Civil Procedure 63 allows me to file the petition 7 days before trial. If you look at statutory construction,
this is not, you're not, Espinoza, I can't give you advice. Just if you're gonna make an offer of proof, you have to make your offer of proof. Like you can't include it as closing argument. You can't just list, you can't tell me what your case in chief is. You have to make your offer of proof. That's really the best I can tell you.
Judge, I'm looking at an article from Judge Serta. I looked at it before I asked you, okay? And by Judge Serta, as far as what my informal offer is. So I apologize that it's frustrating you, but if I had been allowed to show you what the offer would be, I would have been able to argue.
How would I have allowed you? So tell me, if you would have called this witness, they would have provided this. Does that make sense?
Right. So if I had been allowed to call Ms. Robinson,
thank you,
then she would have talked about the cigarette burn, that it looked like a cigarette burn for the injury he received on his back. If you had allowed me to call Kathleen Evans, who is waiting in the waiting room as CASA, she would have told you about the additional outcry that the child made to her, which was that mom had not slapped him, but that mother did not. She would also have testified that mother did not challenge that. She would have also testified as to the concerns that CASA has with regard to the child and the safety of the child. As far as my closing is concerned, I believe the court has seen evidence of bruising, has heard evidence that there have been at least 3 outcries that CPS has received during the time that the mother has had the monitored return. CPS didn't do any further investigation into the December outcry. You've heard evidence that the mother has not gotten the child to school 9 out of the 55 days. And you also heard evidence that mother has been aggressive with someone physically aggressive at a school that other people have observed. So, and as far as his ad litem, I am concerned about his safety. I'm concerned that the department did not make me aware. You've heard evidence of that, so that I could move sooner. I understand the court's frustration, but I do want it duly noted that it was because of coronavirus that we were not able to schedule this sooner. So in closing, I would say it is not in the best interest of this child for him to be returned home safe. A lot of people have tried to put the department on notice so that they could protect this child. But in this case, they have failed to protect him. So I leave it in the court's hands, but I do not believe that this child at his age, with his special needs, as far as his behaviors that the court has heard evidence of, and him possibly being autistic, should have him returned directly to the mother. I think that the court should remove him from the mother. Thank you.
Okay. So having heard the competent evidence, the court will grant the motion to modify. Here's the problem. The CPS is the one responsible for the child. So if we grant this, then we remove the child from CPS. If I don't grant this, then tomorrow the child remains with CPS. Who's the one responsible for everything? Every complaint that you have is CPS is the one responsible for it. So it doesn't matter what I do at this point. So I hope you understand, Ms. Canosa, but at this point, either way, CPS decides, well, it's either CPS decides where the child goes, which is the problem that you have if they decide with mom, or the child goes with mom, which is the problem that you have. So anyways, at this point, Ms. Neighbors, do we need anything else? I don't have an order here. If you can bring one to the court, be happy to sign it.
Yes, Judge, I'll provide one. As soon as
I've already made the docket entry, so it's in there if you need just the signature on the order.
All right, thank you, Judge.
So,
may be excused.
Yes, thank you very much. That'll conclude this hearing.
Thank you, Judge.
Appreciate it.